Thank you very much. That was short, not short enough. As I understand my role this afternoon, I'm to speak informally for a while. I'm not going to read a paper. I've done no research. I'm relying on memory. I haven't reread my report, though I've looked at it to confirm a couple of details. I apologize for not using modern equipment, especially in a group such as this. No PowerPoint presentation. I was trained in a system in which, in the oral system, in which you had to listen and concentrate for long periods of time to someone's voice without the, I call it, distraction of some words on the screen that don't add anything to what the speaker's saying, but stops the listener from being bored by the monotonous voice of the speaker. So you'll have to forgive me for any inaccuracies of memory, and I hope I'm not going to be too long, because I'd rather respond to your interests than inflict on you what I think, what I guess you might want to hear and perhaps guess wrongly. My premise, and it may not be right, particularly because of a discussion we had at lunch, but I take it for granted, and will not justify it, that in our society, privacy about health is an important interest and now right. Like all rights, the right of privacy is subject to limitations, because from time to time it must necessarily yield to a more important transcending right or interest. I really wasn't prepared, had no intention of defending the right of privacy. The other side of the coin is, of course, the obligation of confidentiality on the part of persons who have to respect the right of privacy. And since I know there's some medical people here today, I think you would get into an argument with them if you suggested that that wasn't important for the proper exercise of their profession. They could not do their jobs properly unless they could get information from the patient that they need in order to make a judgment, and the patient would not give that information unless the patient felt that it was for that person's ear and that person's ear alone, subject again to the qualifications which I may mention. If there are any persons here who think that you have to defend the concept of the importance of privacy, I recommend, as I mentioned at lunch, the seminal work on the subject by Professor Alan Weston, then of Columbia University, called Privacy and Freedom, a book that was published as long ago as 1967, about the whole history of privacy and the need of at least our culture for privacy. I accept the fact, I learned during my inquiry that there may be cultures in which privacy is not regarded, or at least, yes, privacy is not regarded as highly as generally it is in what we call Western society, but with, again, qualifications when I say Western society. My inquiry was created at the end of 1997. The public hearings did not begin till 1978, and the report was submitted in 1980. And it was created in response to a few allegations in the media particularly, and I guess maybe in the House as a result of the media coverage, of invasions of privacy, particularly but not exclusively by police officers, obtaining information required to be kept confidential by legislation from such custodians of that information as OHIP and hospitals. Before you can have public hearings, you have to make some kind of inquiry, do some kind of investigation to know what kind of witnesses should be called, to know the nature of the public hearings. And during the course of those investigations, our we were able to discover the true magnitude of the abuses that were taking place, not only in the public sector, which is what was thought to be the beginning of the inquiry, thought to be the purpose of the beginning of the inquiry, but more egregiously in the private sector. I'm going to ask for your indulgence while I tell you about some anecdotes that are illustrative of the history of this problem in Ontario, and as I found out during the inquiry, not just Ontario, but the rest of Canada and, in fact, the rest of North America. There are two anecdotes in particular that I found fascinating, and I think you'll find interesting. One involved the St. Catharines General Hospital, and the other involved a then well-known physician by the name of Dr. Porter. All of this is in the report, so I will not mention names if the names were not now public. Let me talk first about the St. Catharines Incident. I went to the report to get this date, but in April 14th, to be precise, 1977, a very astute medical record technician at the St. Catharines General Hospital, whose name was Mrs. then, Linda Montague, and I really should have dedicated the report to her. She received a telephone call from someone who identified herself as being from the Toronto General Hospital and represented that a patient, we gave the patient's initials, I don't know why this, because it was a fictitious patient's agency, a patient, one JM, was unconscious from a drug overdose and was in the Toronto General Hospital's emergency department at that very moment. The caller wanted Mrs. Montague to read JM's medical history from the medical records at that hospital. He had been, as I recall, a psychiatric patient at the St. Catharines General Hospital. She took down the phone number of the caller. I can tell you the phone number. It was 225-1486, and was told by Mrs. Montague that she would phone her back. She would look at the chart and call her back. She looked at the chart, and she was suspicious. So she checked Toronto General Hospital's phone numbers and discovered that the number that she was given, she phoned the hospital to find this out, was not one of the Toronto General Hospital's numbered. And she called the number, and the number was answered by the same person's voice, the caller, who said, "Mrs. Robinson, Medical Records Department." Mrs. Montague said, "That's not the number of the Toronto General Hospital." And the person on the other side said, "You've misunderstood." I said, "East Toronto General Hospital." So she said she'd return the call, and she then found out that it wasn't the Toronto East General Hospital's phone number. But while she was doing this investigation, she got a call from a man who said, "This is Dr. Henderson in the emergency department of the Toronto East General Hospital. This patient is dying. We need that information immediately." She checked the hospital. There was no Dr. Henderson on the staff of the Toronto East General Hospital. She recorded, Mrs. Montague recorded the events, in fact told her superior, and made a note of the telephone number, which you'll see in a moment was very important. Now, using that information, we were able to obtain a search warrant and got from Bell the owner of that number. And the owner of that number was a company called Paragon Investigation Services. We learned that Paragon Investigation Limited, rather, had been retained or had been asked by another investigation company, private investigation company called Centurion Investigation Company, to obtain some information, and had been retained by an insurance company, a well-known insurance company, Wawanesa. All of this, again, as I say, is in the report as a result of sworn evidence and documentary evidence. And Wawanesa retained Paragon to investigate JM's medical condition. By the time of my inquiry, Paragon had surrendered its charter and was out of business. But an examination of the governmental files showed that all the shares in Paragon were owned by the principals of Centurion, who were, by the way, former Toronto police officers. With that information and the use of a search warrant, we were able to examine Centurion's files, and we discovered that the company, who were private investigators, had been retained by a number of insurance companies and a number of insurance adjusters to obtain confidential information about persons who were hostile in interest to their insurers. In other words, if there's, for example, a motor vehicle accident and there was an expectation that the person injured would sue the insured of the insurance company wanted the medical information from the injured person. They're not in the same interest, they're in hostile interest. And the information was confidential. It ought not to be revealed. But by the use of these pretexts, the kind I mentioned, this information was sought and obtained. Centurion had on its payroll, in its employ, registered nurses who were, because they wanted people who could understand the terminology that was going to be read to them by the people divulging, contrary to law and their professional obligation, this information. The search of, with the use of search warrants obtained from courts, I had no power to issue search warrant, we were able to obtain the names of other clients of Centurion, other insurance companies and insurance adjusters, looked at their files and found out what other private investigators were doing the same thing. And this was happening with great regularity. The information was given out freely by private doctors' offices, by hospitals. Probably, I shouldn't say probably, I conclude because they thought they were helping their patients, because of the pretext being used. Indeed, we discovered a lot of lawyers were doing the same thing, retaining the private investigators and using a formula of words that were really a code for saying, get the confidential information. They didn't say get the confidential information, but the language was the same throughout, and you knew that that's what it meant because that's what they got last time. Indeed, after the publication of the report listing the lawyers who were so identified, I shouldn't say I made the mistake, I refer to them as the cream of the insurance bar. And a lot of other lawyers were very annoyed at me because they weren't listed as part of the cream. At least they professed to be annoyed. So you see, this information had a monetary value, this confidential information. These people retaining the private investigators were paying for the confidential information. Just coincidentally, much later, as in my judicial capacity, I had to decide the case whether or not decide whether you could steal confidential information, whether it was of something that could be stolen, whether it could be the subject of theft. I held it was not. As the law then stood, I guess still stands, that decision went to the Court of Appeal and ultimately the Supreme Court of Canada, and that decision of the Supreme Court of Canada was to the same effect. Now let me move to the other interesting. By the way, let me tell you that when the inquiry was created, if you look at the terms of reference of the inquiry, you'll see that it really referred to examining the public sector. On the first day of the public hearings, the first witness, I believe it was the first witness, was an insurance adjuster represented by a man who became eventually the Attorney General of Ontario, who stood up and said, I have an objection to your looking into this because your inquiry is supposed to be looking only at the public sector. This is not the public sector. I want you to apply to the divisional court for a determination whether you have the power to do so. I said, looking at the terms of reference, I will do that if the government doesn't enlarge the terms of reference. I went back to the government, explained the problem, and in due course, a new order in council was issued authorizing a commission, enlarging the inquiry. So I was able then to look at the whole picture. Let me turn to Dr. Porter. Dr. Porter was a medical doctor, and quite well-known medical doctor, who in the course of his practice became a coroner. And as a coroner, he was well known to many Toronto area hospitals. Later, he became I'm not sure if a or the medical claims adjudicator with OHIP. And as any doctor who submits accounts to OHIP knows, not a person to be alienated. But while he was employed as a claims adjudicator, still on the list of coroners, but not an active coroner at this time, he was retained by various insurers and insurance adjusters to carry out medical examinations, review hospital records, and express an opinion about the scope and disabilities of claimants involved in auto accidents. Again, persons who were suing or were likely to sue the insurance companies to whom Dr. Porter was to report. And he got paid for each report. His method of operation was fascinating. This evidence came from people in the hospitals to whom he approached, and his own evidence, because he didn't deny any of this. He tried to justify it, but he didn't deny it. He said that he would go to a hospital, and they would say, "Oh, there's the coroner, there's Coroner Porter," and he would go look at X-rays, look at charts. In some occasions, first of all, he'd go to, or I shouldn't say first of all, often he would go to the doctor's lounge and borrow a lab coat, put a lab coat on, and on some occasions go to the nursing station and get a stethoscope and go in it and actually physically examine the patient about whom he was going to report to an insurer or an insurance adjuster. All right, another example of the value of this confidential information. It had a value which you could fix by seeing the fee that he got for it. The report is replete with examples of the information. Then there were examples, because there were tons more, of the kind of information that were given. And you would be horrified if you read them. I mean, I'm not trying, you can't buy the report, so I'm not trying to sell you the report. It's out of print and I think largely, perhaps not largely, forgotten. But there are examples there of terrible information being given. Some of it wrong, we found out, but it doesn't matter, given to people who had no right to ask for it, and by people who had an obligation not to give it. Private physicians in their private offices, usually the physicians themselves, somebody on the staff of the physician, sometimes the physician. By the way, you should look at the medical records. In those days, I don't know if they're any better today, they're unbelievable. The information that was in them had nothing to do, there were a lot of irrelevant to the purpose of the examination. And examples, again, are found in the report. Sometimes this information was given without the use of pretext, just given, without any thought. The only persons who, as a practical matter, were denied access to the information were the patients themselves. I'm going to come back to that. And sometimes, perhaps even often, they were asked to sign a consent to the release of that information to third parties and didn't even know what they were releasing, as a result of which some were denied insurance, some were denied employment, in some of those cases where the information was dead wrong, the information that caused them to be denied the benefits. Now let me turn to another source of breaches of confidentiality, the police. I referred earlier to allegations about police obtaining confidential information that should not have been released to them. Pardon me. And here I get into the question of the need, perhaps, to qualify the absolute right of privacy. That occurred. They did get such information. They got it from OHIP. In fact, and I think more than one occasion, but certainly one occasion that comes to mind immediately, the OPP, Ontario Provincial Police, had an office within OHIP's office so that they could look at the records more conveniently. The RCMP got confidential health information for a number of reasons. Sometimes, and this is recorded in the report eventually, was part of the MacDonald inquiry into the RCMP. That's where they got the information from our inquiry. Used to disrupt what they consider to be subversive organizations. The municipal police got it, sometimes by threatening hospital employees that if they didn't give them the information, they would be charged, the employees would be charged with obstructing justice, which of course was impossible to do. They're not obstructing justice in a situation like that, but they wouldn't have known that. The employees wouldn't have known that. At the present time, right, this very, well, I shouldn't say today, but in the last couple of weeks, and probably still, in Toronto, there's been a lot of gun violence. And you've probably heard or read about the Chief of Police of Toronto urging the making mandatory of it mandatory to report gunshot wounds and stabbing wounds. That's not now the law. And there's a lot of belief. There's a belief in Canada that it always was the law because it is in the States, and we get all our information about the law, as you know, from the States. I'll come a little more fully, not terribly fully, but a little more fully to the recommendation in a moment. My recommendation was that ought not to be the case, that there ought not to be any obligation on hospital employees and physicians to report gunshot wounds on the part of their patients or stab wounds. And I'll come back to that in a moment. I, however, was not of the view that there wasn't some justification for making a change in the law that prevented physicians and hospital employees from revealing information, but I'll come back to that in a moment when I tell you about give you a few anecdotes about situations in which I think any fair-minded person would say the absolute prohibition against revealing that information is not in the public interest. The first anecdote arose out of a submission written submission and oral presentation, a magnificent one, by the London police force. This is the story. In 1969, a man by the name of Russell Johnson, again a name that's public, that was public, we recited it as in the report, had seen a psychiatrist at the London Psychiatric Hospital. And actually he was with his wife when he saw the psychiatrist, and told the psychiatrist that he'd broken into an apartment and serially, it turned out to be right, it was serial, but on this occasion, just one. He had sexually assaulted a woman. He was admitted as an inpatient at the London Psychiatric Hospital, and at the time, the police were investigating that crime, but had not been told anything by the psychiatrist. You perhaps can't fault the psychiatrist in that situation. There were a series, this is the serial part, there were a series of sexual assaults from 1969 to 1977. 7 women were killed and 10 others were sexually assaulted. I told you I went to the report to get some details, and that's where that comes from. Johnson was arrested in July of 1977 and charged with the murder of 3 of these women. And he was found not guilty on account of insanity. The police submitted, this was the nature of their submission, that if the original information had been made available to them, the other crimes would not have been committed and lives would have been saved. You're going to be thinking about what to do in that situation, and I may come back to that. The second anecdote involved the Woodstock General Hospital, and the administrator of that hospital gave this story. The local police had been contacted by the police in another jurisdiction where a hijacking of an aircraft was taking place at that very moment. And he satisfied himself that it was indeed the police who were calling. And that's a very important thing, because these pretexts, remember, people can say they're the police and give information. It's a legitimate call. But anyway, this was verified. And they said, there's a hijacking taking place, and we know that the hijacker was a patient in the Woodstock General Hospital. We want to know as much about that person as possible to know how to handle the situation. Would you read us the chart? As I say, he's confirmed that that was the police were calling. He went to the chart and he read it to them, and he said, I knew I was doing something which I was prohibited from doing under the Public Hospitals Act. But I would do it again if it happened today. What about that? How absolute should the right of privacy be? The revealing of information without the consent or even knowledge of the subject of the information. You want any more anecdotes? They all raise the problem. This is a Toronto case. A man entered a shop, I think it was a cleaning store, cleaners, but it doesn't matter the nature of the shop. And he just came in and he was noticed by the female clerk. He didn't stay, he left. Transacted no business, left. The next day, he returned with a cast on his arm. And that had not been there the day before when he first came. he raped the clerk and robbed her. The police, on being told of the episode, assumed, as any reasonable person would, that the cast had been applied at a Toronto hospital between the first and second visits. But not knowing which hospital, they could not obtain a search warrant to go to the hospital and get any records. So they canvassed all the hospitals in the area, and with a description of the assailant, and the hospital employee recognized the description and said, by the way, right now, I'm confusing this with next to it. Yes, we had him, here's the information, gave him the information. As a result of which, the assailant was arrested and eventually convicted. That information should not have been given under the existing legislation. The next case is a case that I was confusing it with for a moment. There was a discovery by the police of a body stabbed to death. But there was a blood trail leading away from the body, which led the police to infer, correctly, as it turned out, that the assailant had also been stabbed or cut. They went to the nearest public hospital emergency department, and an employee told the officers at this very moment there's a patient there's a patient being sutured for a stab wound by a physician in the emergency department. That was the man. They arrested him. Most police forces, I discovered, have a file which I think was called E&D for one police force, I'm not sure, erratic and deranged. They're people who behave strangely, and whenever a famous person comes to town, whether it's a member of the royal family, a prime minister, a pope, or so on, some threats are made. In order to determine whether the threat should be taken seriously by the security forces, they want to know something about the person who made the threat. And they often went to psychiatrists to find out whether something about the patient in order to make that judgment. And in fact, this issue was an issue that went all the way to the Supreme Court of Canada, because we were able to satisfy ourselves about a certain number of psychiatrists who could be identified and why they did it, but there were still some others, and just to make sure that their justification was that they had a justification, I wanted the names of those psychiatrists. I was refused the names. I said, there's no privilege on the part of people who are breaking the law wrongly. That was wrong. Went to the Court of Appeal, the Divisional Court, the Court of Appeal, and the Supreme Court of Canada, and the Supreme Court of Canada said, no, you're not entitled to that. There's a privilege, the police informant's privilege, which can only be broken to prove innocence. And that's now the leading case on the question of police informant privilege. But anyway, that's what was happening. They were giving out information to the police about their patients who had made threats. Now, in all these cases, and there are more, but I think that's enough to show the nature of the problem and the issue whether privacy should be accorded an absolute right, is an absolute right, or should be qualified. In all of these cases, disclosure was improper. But was there not in each case another interest that was more important than that of patients' privacy? I nevertheless resisted the invitation and even the temptation to require that this be reported, mandatory reporting of this I did not think that physicians and hospitals, but let me just speak of physicians, had a function to act as agents of the state in law enforcement. I thought that their concern was the care and treatment of people who needed care and treatment, and that it was not in the public interest to prevent people who needed care and treatment, even if they were malefactors, from seeking medical attention because of the fear that that would expose them to arrest. But I did say that the existing language in the regulations under the Medical Act that required physicians to keep information confidential was really not good enough, that there ought to be a discretion on the part of physicians, not an obligation, not a mandatory obligation, as a result of which they would be themselves committing an offense if they didn't report. And physicians do this all the time, by the way, not report where they have to. I'll come back to that in a moment. But permit them to, in their discretion, to notify the authorities. Then it shouldn't be an offense, even a disciplinary offense. And I could read you, I won't take the time, you might not want me to anyway, to read recommendations 20 to 24 that deal with this aspect of the matter. There are, as you know, obligations under various statutes on the part of physicians and hospitals to report. You know about child abuse, driving by persons who ought not to be driving, what are now called certain sexually transmitted disease, but in those days were called venereal diseases. And a decision obviously has been made by legislatures acting in the public interest that these were the public health, the prevention of transmission of these diseases or harm to, say, the children, were interests that transcended in importance the interests of the patient's privacy, and that they should be, in those situations, required to report. And that's a judgment that the legislature is entitled to make. And when the evil is large enough to justify the overriding of an interest, then that should be done. But the question of what kinds of situations justify the overriding of privacy concerns is a difficult one. And an example was given by a physician, well, several physicians, but one in particular, when we were looking at the obligation, the mandatory obligation, redundant, the obligation of physicians to report certain, as I say, they were called venereal diseases in that part, and at that time, and the physician who was in charge of a very large clinic said that he did not report, despite the fact that at the time, I don't know if the situation is still the same, he did not report cases of gonorrhea. He didn't think that was important enough because gonorrhea was so easily treated. And one physician said, publicly, I do not report sexually transmitted diseases if the patient is a physician or a clergyman. That surprised me, but that was the position, and he wasn't afraid to say it publicly. Now, probably what I'm not going to spend any time on this, but probably what you're most interested in this kind of a gathering would be most interesting is that dealing with research. To what extent are privacy concerns do privacy concerns stand in the way of research? I dealt with that in a long recommendation, qualified the right to privacy because research is in the public interest and is a very important public interest. but created, or recommended, I created nothing, recommended safeguards to protect privacy as much as possible without in any way preventing helpful research from being carried out. How are we doing? Huh? I want some time for some discussion. That's my concern. Anyway, let me come to what was clearly the most, what shall I say, sensitive and let me leave it at that, sensitive issue, and that was the access to one's own health information, which did not exist at the time. And indeed, the arguments that were made for preventing patients, even in the light of the evidence that people were having access to, say, my information, who weren't entitled to it, I wasn't. I wasn't in a position to be able to correct any misinformation, and there was lots of misinformation in any kind of a record, or not lots. There are often misstatements that can negatively affect the individual, the subject of the information. And the arguments were mainly paternalistic. The physician knows best, and all the patient has to know is that the patient is in good hands, and that's enough, or whatever the physician thinks the patient should be told. And that, for most of us, is probably good enough, but some patients want to know the information. Sometimes they need to know the information, and they had no right to it. We were told, well, for one thing, they wouldn't understand the chart. And this example was constantly repeated. For example, we use short forms. And if a patient saw on his or her chart SOB, which to us means shortness of breath, they might feel offended. And they said, and this eventually became an issue in the Supreme Court of Canada, in a case I'll mention in a moment. They said physicians would be deterred from recording things that they otherwise would record if they knew that their patients could have access to the charts. I thought that was a specious argument. I didn't think any physician in good conscience would leave out of a chart anything that was necessary for the care of the patient, not just for that physician's later reference, but suppose the physician retired or died and someone else needed access to the history. I didn't think that merely because of the possibility that a patient might say, I'd like to see my chart, the doctor would leave out important information. Some of the other information that's left out was well left out, if you look at my report, you'll see. In any event, that was the most controversial issue. And I'm not going to take that. I was going to read you the actual the text of my reasoning in it, but I think in the interest of time I will not. Now, what happened later after the report was submitted? This is very interesting. This has something to do with the way in which reports of royal commissions, which are, that's a misnomer by the way, but they're called royal commissions, are dealt with, is exemplified by what happened in this case. The government, on receiving my report, created a task force of one person, a very eminent person, a very eminent physician and a hospital administrator, Dr. James Galloway. And I say that sincerely. He was a very eminent and wonderful man. And they asked him to look at my report, at the recommendations of my report, and I have now his report. I mean, in my hands I have it. And it's a report on the practical implications to the healthcare system and providers of consumers of care of implementing the recommendations of the report of the Commission of Inquiry into the confidentiality of health information. And what Dr. Galloway did was take my recommendation, set it out, and then make his comments. His comments were made after discussing with people who were concerned, all of whom, by the way, had appeared before me and all of whom I looked at, to see what they thought. And then he would say, this is what they thought, and I recommend that this recommendation be implemented. Most often that was the case. Sometimes he said he didn't think so, but that was the minority. But when it came to the recommendation about access to one's own information, he devoted many, many more pages to that recommendation than to any other one. Pages. Most recommendations were dealt with several on the same page. This one was very lengthy, and here's the recommendation. It is recommended that before any decision is made to implement recommendations 82 to 85, access to one's information, of the report, that an ad hoc advisory task force of persons with expertise and experience be set up to examine all the implications of recommendations 82 to 85 and to advise the minister whether these recommendations should be implemented as submitted or in modified form. So let's have another inquiry into the inquiry. But to its great credit, and I can't remember the precise date of this, the College of Physicians and Surgeons made a policy decision that patients were entitled to access to the report. That was Ontario. In 1992, a case went to the Supreme Court of Canada called McInerney and MacDonald. That's 12 years later. And the Supreme Court of Canada, quoting my comment that I didn't think any self-respecting physician would leave out of a record any information that was necessary for the care of the patient, held that patients were entitled to access, patients anywhere in Canada, not just Ontario where the college said, were entitled to access to the information. And they now have it, the right. I don't know how many of them take advantage of it, and the world has not come to an end as a result of their access. I think maybe I should stop. Should I? It may be that some of the other things I was going to say may come up depending on the questions. Right? That's it.